Imagine you're an in-house lawyer at a major company and you have to go to your direct report, the general counsel, the CEO, or chair of the board of directors, and tell him or her the following. Recall that we're defending a class action case in federal district court? Well, the judge concluded that I, as the in-house lawyer, violated state bar ethics rules and imposed sanctions on me and the company. I'm prohibited from practicing law in that district for at least 2 years. And after those 2 years, I can only reappear in that court after taking 5 hours of ethics courses. And a monetary sanction has been imposed against the company in the amount of $100,000. This scenario is not a hypothetical. It's based on an actual decision by a magistrate judge in the Southern District of Florida. And it was not based on conduct that was obviously unethical. As a class action defense lawyer, I'm passionate about not only helping clients achieve the best result possible on the merits when defending these cases, but also helping the in-house lawyers I'm working with avoid conversations like this one. Over the next 30 minutes, you'll learn how to avoid 5 ethical traps when defending class actions, including the trap that resulted in the sanctions I just described. We want you to avoid looking like this guy. You can receive ethics credits for this program and is intended to provide important practical advice for any in-house lawyer dealing with class actions. The 5 ethical traps we will cover deal with communications with class members or putative class members and settlement of class actions. I'm not an ethics lawyer. I'm an attorney who defends class action cases. So while we will discuss the applicable ethical rules, we will also focus on real-world practical problems and solutions. My promise to you today is that I will not raise an ethical problem that you may confront for which I do not also provide a solution. As you know, ethical rules apply to you as a member of the bar. Individual states have their own rules, so it will be important, critical, to check the rules of the state in which you are practicing regarding the issues we discuss. But there are also ABA, American Bar Association, model rules that many states follow in whole or in part and on which we will focus today. The ABA model rules have been adopted in 50 states in some form or another. As of November 1st, 2018, California was the 50th state to join in following a form of the ABA model rules. I will also reference ABA ethics opinions, which provide guidance to lawyers about how to interpret the ABA model rules when particular scenarios arise. Such opinions are often accorded great, even dispositive weight by some disciplinary agencies or courts dealing with identical or analogous ethical questions. It's important to be aware of these ethical rules because the last place any outside counsel or in-house lawyer wants to find themselves is on the wrong side of an ethics opinion or court decision impugning their ethics. We want you to avoid having a conversation described at the outset. Now, class action poses special challenges for in-house lawyers. Often the stakes are high. A single plaintiff can allege claims on behalf of thousands of others, and with astronomical damages claims, sometimes enough to bankrupt a company. In other words, they can be bet the company cases. Almost any class action is expensive to defend, and the costs of discovery alone can be staggering. Cases like these have the attention of the highest levels of management, and they may unknowingly push you to take actions that would have you fall into an ethical trap. This is especially troublesome when the traps are not obvious and may be camouflaged by moves that would be reasonable under different circumstances or if you were not a lawyer. As I mentioned, I will focus today on communications with companies' customers and settlement negotiations because those are 2 areas especially dense with ethical traps. Let's start first with communications with your customers. Here's the scenario. Your company has been sued in a consumer class action, And the class definition covers all of the company's customers over a 4-year period. The CEO approaches you and says she wants the company's lawyers to call customers and offer to give them what's reasonable in exchange for a waiver of their claims. After all, they're the company's customers, and the company communicates with them on a regular basis about all kinds of things. And this is good customer service to make them happy. This is ethical trap number 1. If a class has already been certified, this is a problem. Why? ABA Model Rule 4.2 addresses communications with a person represented by counsel. It provides that in representing a client, a lawyer shall not communicate about the subject of the representation, in other words, the litigation, with a person the lawyer knows to be represented by another lawyer in the matter, unless that lawyer has consent of the other lawyer or is authorized to do so by law or a court order. As held by the U.S. Court of Appeals in the 11th Circuit in the Kleiner case, defense counsel has an ethical duty to refrain from discussing the litigation with members of the class as of the date of class certification. Now, why in Kleiner was the trigger date the date of class certification? Because that's the date the 11th Circuit concluded that a lawyer representing the named plaintiffs also represented the other members of the class. Some courts hold that the attorney-client relationship between plaintiff's counsel and your customers is formed even before the time period for customers to opt out of the class expires. And flipping the majority rule on its head, at least one state, Pennsylvania, holds that putative class members are deemed to be represented by counsel from the moment the case is filed until class certification is denied. Accordingly, the company's outside and in-house counsel may be prohibited from communicating with its customers about waiver of claims. In other words, prohibited from communicating about settlement of the lawsuit in which those customers are represented by counsel. You may be wondering whether it might solve the problem to have the company's customer service agents make the calls rather than counsel. You may have noticed that ABA Model Rule 4.2 addresses communications by lawyers, not other company employees with different degrees. On a related note, ABA Formal Opinion 11-461 provides that parties to a matter have the right to communicate directly with one another. A lawyer may advise a client of that right and may assist the client regarding substance of the proposed communication with the other side. The lawyer's assistance need not be prompted by a request from the client. In other words, the lawyer can initiate that idea. Such assistance may not, however, result in overreaching by the lawyer. This is a problem because what constitutes overreaching is unclear. Additionally, a lawyer may not use an intermediary, an agent or another, to communicate directly with someone represented by counsel in violation of the no contact rule. ABA Model Rule 8.4 says that it's professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct through the acts of another. Some guidance suggests that if the communication is scripted or masterminded by the lawyer, that it would be a violation. However, what constitutes scripting or masterminding the communication is also unclear, leaving this area fraught with peril. Now, I promised at the outset that I would not identify a problem without also identifying a solution. In other words, I would not tell you about an ethical trap without also providing ways you can avoid or escape it. A solution here is to communicate directly with members of the putative class, if at all, before a class is certified. While there are a few states that take a more restrictive approach, and you must, of course, follow the applicable state that applies to your issue, this is the ABA's approach that most states follow. The ABA has issued a formal ethics opinion that directly addresses whether you can communicate with members of the putative class before the class is certified. It's ABA Formal Ethics Opinion 7-445, and it provides that before a class action has been certified, counsel for both plaintiff and defense have interest in contacting putative members of the class. The model rules of professional conduct do not generally prohibit counsel from either the plaintiff or the defendant from communicating with persons who in the future may become members of the class. So that presents another question. If your communication with members of the putative class is prior to class certification, are you clear to proceed? The answer is yes, with qualifications. This leads us to ethical trap number 2. Obtaining something from the putative class members, for example, a release or a declaration, without advising them about the pending class action. The business people often hate this. You'll hear things like, "You mean to say that we have to advertise for plaintiffs' lawyers?" There are a number of ABA model rules that apply to your communications with putative class members, even in advance of class certification. ABA Model Rule 4.3 provides that a lawyer should not state or imply that the lawyer is disinterested in dealing on behalf of a client with a person who is not represented by counsel. And ABA Model Rule 4.1 provides that a lawyer shall not make a false statement of material fact to a third person. ABA Model Rule 8.4 provides that it's professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Additionally, Federal Rule of Civil Procedure 23 allows the court to restrict communications with the putative class under its supervisory powers. This really all boils down to, is your communication with the putative class members misleading? The case law provides guidance. In the words of the Central District of California in the Parks versus Eastwood Insurance Services case, courts routinely hold that releases are misleading when they do not permit a putative class member to fully evaluate the likelihood of his recovery through the class action. Defendants have an obligation not to conceal the difference between participating in the class action and accepting short-term payment through the claims process. Parks dealt with a company sued in multiple class actions over a crude oil spill in Santa Barbara County. The company notified the victims of the oil spill using online print advertisements stating that the company is committed to doing the right thing, including making appropriate financial reparations for any verified damages or losses directly caused by the spill. The ads encourage victims to call the claims line and visit defendants' response sites, but did not mention the pending litigation or advise victims to consult counsel before contacting the defendants. The ads gave victims the opportunities to sign settlement agreements. The first release made no reference to any pending class actions, and the second release notified claimants of the name of the class action and stated that the payee, in other words, the settling party, is informed and understands that the payee may be eligible to participate in the class action, but instead has chosen to enter into this agreement. However, it still did not advise them to consult with counsel before signing the release or explicitly notify the payee of his or her right to do so. While the court did not find an ethics violation, it did find a Rule 23 violation. It held that, and I quote, "Although the second release notifies victims that a consolidated action exists, it does not provide additional information, such as an explanation of the plaintiff's claims or the contact information of plaintiff's counsel." It held that courts routinely hold that releases are misleading where they do not permit a putative class member to fully evaluate his likelihood of recovering through the class action. Defendants have an obligation not to conceal the difference between, on the one hand, participating in the class action and on the other hand, accepting the short-term payment through the claims process. Similarly, I defended a class action case where prior counsel, before class certification, worked with the company's customer service representatives to do a phone campaign with the goal to return some or all of disputed amounts and reach settlement agreements with waivers of claims. Once the plaintiff's counsel got wind of it, they asked the court to enjoin the practice, claiming that the communications were misleading because they failed to inform customers about the uncertified class action. The court agreed. It required curative notice to be provided at the company's expense and allowed any of the customers to rescind the settlements. Ultimately, the case was settled on a class-wide basis, with the company getting very little out of its pre-certification settlement effort, other than significant little litigation expenses on a side issue and negatively coloring the court's view of the company. The best practice here is to A, provide sufficient information to allow potential class members to decide whether to accept a settlement offer, B, explain the effect of settling, and C, advise how putative class members may proceed if they choose not to settle, including participation in the class. Ideally, do this in writing so there's a clear record about the company's disclosures. In obtaining the settlement releases, another pre-certification communication that can be fraught with peril is obtaining declarations from company employees when they are also putative class members. For example, in the Kazeta case, the company's counsel met with the company's employees to obtain declarations. However, the company's counsel failed to explain that the declaration could be used in plaintiff's lawsuit to limit that employee's and others' recovery. Some employees said they felt pressure to sign, and out of the more than 100 employees at issue, only 6 did not sign a declaration. The court held that this was coercive and unethical. It ruled that defendants could no longer communicate with the putative class members, their own employees, about the lawsuit without prior court approval. The court also ordered that a curative notice be issued to the class explaining that any declarations employees provided would not be considered by the court, and that the defendants could not retaliate against their employees if they chose to cooperate with plaintiff's counsel. To help provide you with guidance, let's talk about a few examples where a company or its counsel had pre-certification communications with putative class members and were found not to have made any ethical violation or run afoul of Rule 23. In other words, these are the good cases. In the Bobrick case, it was pre-certification. Defendants' attorneys obtained declarations from some of defendants' employees. While putting the disclosures in writing best protects the interests of the company, this case illustrates that a script for oral communications can also be effective. Prior to obtaining the declarations, the attorneys read a script to the employee. It made 7 points. The first 2 points told the employees who the lawyer represented, about the lawsuit, and that a class was not yet certified. The third and fourth points told the employees how the employer planned to use the information provided in the declaration. The fifth, sixth, and seventh points told the employee about the procedure. They could review the draft declaration. The employee was not required to speak with them. There would be no retaliation if they did not speak with them, and it would not be shared with the employee's manager. In other words, points that were negated that might cause the employee to feel forced to testify in a particular way or to sign the declaration. The court held that this was not an ethics violation, nor was it abusive, coercive, or misleading under Rule 23. In fact, the court rejected the argument that the communication was misleading because it omitted the plaintiff's counsel's contact information, a neutral advertisement of plaintiff's theory of the case, or the right to speak with class counsel. Instead, the court examined the entirety of the defendant's conduct and communications and found there was no statutory rule or case law that required defense counsel to give specific information and instructions to putative class members. Now, notwithstanding that case, keep in mind that while telling the settling individual or declarant about the class action is the best practice, this will help you avoid trouble, although not every court has required it. While there is authority finding no violation where a defendant did not mention the pending class action, this is an area where the company needs to tread carefully. Let's talk about another settlement scenario. The company has been sued in a consumer class action. You believe that the class action is lawyer-driven, and if you settle on an individual basis with the one plaintiff who brought the class claims, there is unlikely to be a different plaintiff to step forward to file the same lawsuit against the company. That is, unless this plaintiff's lawyer with whom you are considering settling manufactures another lawsuit. Your CEO says it's fine to settle, but instructs you to include a provision in the settlement agreement stating that this plaintiff's counsel is not, the moment he's paid to settle this action, to refile essentially the same class action lawsuit with a different plaintiff. Sounds reasonable, right? This is ethical trap number 3. A settlement agreement cannot contain a clause that the plaintiff's counsel will not again sue the company. ABA Model Rule 5.6 applies here. It provides that a lawyer shall not participate in offering or making an agreement in which a restriction on the lawyer's right to practice is part of the settlement of a client controversy. A case that addressed this model rule is Adams versus Bell South Telecommunications. This is the case I mentioned at the outset regarding the sanctions recommended against in-house counsel by the magistrate judge who investigated what transpired in connection with the settlement of the action. In Adams, it was a putative class action. The settlement offer was for a $1.5 million payment to the class, and it was discussed at the mediation that plaintiff's counsel would not again sue the company. One of defendant's outside counsel, an associate who was in the room, noted that an agreement not to sue the company again would violate ethical rules. It was then suggested that perhaps Bell South could hire plaintiff's counsel via consulting arrangement to prevent their future representation of persons against the company. That's because the plaintiff's counsel would have a conflict of interest that the company wouldn't waive. The ultimate settlement amount was $1.6 million, $100,000 more, with $120,000 of that $1.6 million identified for the consulting agreement. Again, the idea was that the consulting agreement would prevent further lawsuits because the company would be a client of the plaintiff's counsel and he could not sue his own client. The court held that this practice violated Rule 5.6. The court cited ABA Ethics Committee Formal Opinion 93-371, which outlined 3 public policy goals behind the rule. First, if such agreements were permitted, they would restrict the access of the public to lawyers who, by virtue of their background and experience, may be the very best available to represent those individuals. Second, the use of such agreements may provide clients with rewards that bear less relationship to the merits of the claims than they do the desire of the defendants to buy off the plaintiff's counsel. Third, the offering of such restrictive agreements places the plaintiff's lawyer in a situation where there is a conflict between the interests of the client and those of future clients. The court reasoned that by commingling the financial consideration of the consulting agreement with the settlement monies already offered, Bell South pitted the financial interests of plaintiff's counsel against their client's interests. This stance also gave a clear financial motive to the plaintiff's counsel to undercut their client's interests by taking as large a percentage of the settlement as they wanted in consideration for the practice restriction/consulting agreement. While the Article III District Court judge eventually found that the sanctions recommended by the magistrate judge were too harsh, I'm sure that the in-house counsel subject to the sanctions was not in the best place while the magistrate judge's recommendation was pending. And the in-house counsel was still ultimately required to complete at least 5 hours of ethics courses prior to their reappearance in the district, and they were required to provide a copy of the court's order about their ethics violation to any state bar in which they were admitted. This is, of course, still not a desirable situation, although I'm sure the in-house lawyers were relieved that the company didn't have to pay $100,000 in sanctions. Again, I promise I wouldn't raise problems without also providing solutions. And while you, of course, need to check the law in your jurisdiction, the best the company can probably do here is to have what are referred to as no present intent and no inventory clauses in the settlement agreement. We have forms that from time to time we include in settlements with appropriate customization for the particular case. But essentially, the no present intent clause contains a representation by plaintiff's counsel that he has no present intent to sue the company, and the no inventory clause basically provides the plaintiff's counsel has no inventory of other plaintiffs waiting in the wings to file the same or similar lawsuit against the company the moment this one is resolved. Indemnity agreements for third-party claims are commonplace in corporate transactions. They allocate the risk of, when there is a third-party claim, who will be responsible for it. The CEO instructs you to include an indemnity provision in the settlement agreement with plaintiff's counsel. This is ethical trap number 4. Simply asking plaintiff's counsel to provide indemnification is an ethical violation. This rule stems from ABA Model Rule 1.7, which provides in part that a lawyer shall not represent a client if there's a significant risk that the representation of the client will be materially limited by the personal interests of the lawyer. Numerous state court ethics opinions in Arizona, Indiana, Illinois, Kansas, New York, and others have examined the issue and all concluded that's an ethics violation for defense counsel to request and for plaintiff's counsel to agree that plaintiff's counsel will indemnify defendants for claims by third parties. The rationale for these decisions is that it could create a conflict by placing the attorney's interests at odds with his client's. Plaintiff's counsel may look to the client to provide indemnification so that he can avoid his similar obligations under the settlement agreement. The solution here is don't ask for an indemnity provision. Consider purchasing insurance to cover it if you don't already have an applicable policy, or simply take the risk of a third-party claim into account when agreeing on the settlement amount. Related to some of the issues we've been discussing, there are times when plaintiff's counsel is about to do something for their benefit and to the detriment of the class. A natural reaction as defense counsel is, it's not our issue. But this is ethical trap number 5. Not speaking up when plaintiff's counsel is abandoning their duties to the class, especially when it could cause the judge to reject final approval of a class settlement. Keep in mind your goal is settlement approval. This is what buys the company peace and resolves all the claims on a class-wide basis to put the issues raised in the lawsuit behind the company. So you want to help plaintiff's counsel avoid unwittingly or intentionally violating their ethical duties to the class in a way that could jeopardize your class settlement. Let's talk about a decision issued earlier this year out of federal district court entitled Ma versus Harmless Harvest. Harmless Harvest is a manufacturer of coconut water that was advertised as 100% organic and 100% raw. Plaintiffs alleged Harmless Harvest coconut water was sold at a premium due to these advertisements, yet they were untrue according to plaintiffs. For example, plaintiffs alleged that Harmless Harvest purchased coconuts from roadside vendors with no idea whether the coconuts were grown organically or not. The parties settled for injunctive relief and a $575,000 payment in attorney's fees, expenses, and costs, and incentive awards, which included a $20,000 incentive award for the named plaintiffs. The injunctive relief provided that defendants would no longer make the advertisements, and an independent third-party consultant would for 2 years review the accuracy of the labels. Defendants underwent the expense of mediation, settlement documentation, preliminary class approval, notice to the class, only to have the settlement rejected. The court reasoned that the settlement essentially provided for $500,000 to class counsel and a $20,000 incentive fee to be divided among the named plaintiffs, but offered injunctive relief that was worth little, if anything, to the class, because Harmless Harvest had removed the raw and 100% organic labels voluntarily before the filing of the complaint or execution of the settlement agreement. In other words, the purported injunctive relief does not require Harmless Harvest to do anything it had not already voluntarily decided to do. And there was no showing that absent the settlement agreement, it would seek to reintroduce the labels in the future. So in rejecting the settlement, the court concluded that the class was receiving nearly valueless injunctive relief in exchange for a broad release, while class counsel and class representatives were receiving the only real benefit from the settlement agreement. Of course, plaintiffs and their counsel were not paid, but also Harmless Harvest did not achieve the peace it desired because the class-wide claims remained, and it spent a bunch of money on attorney's fees and class notice with nothing to show for it. Now, this is not to say that you'll be advising plaintiffs' counsel to demand more in settlement negotiations, but counsel should be thinking through whether a settlement confers sufficient benefit to the class in light of the claims made such that the court will approve it. There are other ethical questions that will, of course, arise when litigating or settling class action cases. For example, can you ethically take plaintiff's counsel up on his or her offer to dismiss a federal court action in favor of settling in state court, where the judge may be more likely to approve a settlement? I'll leave that one unanswered in this presentation, although I will say that I'm aware of at least one federal appellate court decision that is on point and the result of which may surprise you. Suffice it to say for now that shortly after a demand letter is served or a putative class action is filed, you should work with outside counsel to map out your litigation strategy and, if applicable, settlement strategy, keeping in mind to avoid ethical traps. Your and the company's realistic litigation and settlement goals can likely be achieved if handled in the right way, even in the troublesome areas we discussed.
Thanks for watching LAWDITION. Continue watching programs that will challenge your thinking, while getting to know the best lawyers in every field as they share their insights, and all while satisfying your CLE requirements. When lawyers audition for new clients, everyone wins.